Good day
Good
to you
day to you
all,
all,
and
and
welcome to
welcome
this
to
Talking
this Talking
Safety
Safety
podcast, where we
podcast, where we
discuss all
discuss
things
all things
safety.
safety.
We are here
We're
to
here to
educate,
educate,
entertain,
entertain,
and
and
inspire health
inspire
and
health
safety
and safety
professionals.
professionals.
With me
With
today,
me
I
today,
have
I have
Ambrose
Ambrose
Ssentongo
Ssentongo
from the
from the
Department of
Department of
Occupational Safety
Occupational
and
Safety
Health,
and Health,
Ministry of
Ministry
Gender,
of
Labor and
Gender,
Social
Labour and Social
Development.
Development.
Before we
Before
start,
we
I'll
start,
ask
I'll
Ambrose
ask
to
Ambrose to
introduce
introduce
himself
himself
and tell us
and tell
briefly
us
about what he
what
does,
he does,
and then we'll
and then
start.
we'll start.
Ambrose, over to you.
Okay, hello Ronald. Thank you very much for the time that we have together today. My name is Ssentongo Ambrose, and I am a Principal General Safety Inspector with the Department of Occupational Safety and Health in the Ministry of Gender, Labour and Social Development. That department essentially is the sole entity responsible for regulating occupational safety and health in the country. So I'm very happy to be here to educate, entertain, inspire, and also the other way around. Be educated, be entertained, and be inspired, of course, through our listeners. So thank you very much.
Thank you,
Thank
Ambrose.
you,
Thank
Ambrose.
you.
Thank you.
We'll be
I will be
talking
talking
about
about
the health
the
and
health and
safety,
safety,
legal and
legal and
regulatory
regulatory
environment.
environment.
So, as
So,
our
as our
listeners
listeners
and viewers may
viewers
be
may be
aware,
aware,
in
in
April
April
2025,
2025,
following
following
presidential
presidential
assent,
assent,
Uganda
Uganda
strengthened its
strengthened its
occupational safety
occupational
and health
safety and health
regime.
regime.
It's
It's
important for
important
us
for
as
us as
listeners and
listeners and
interested
interested
parties
parties
to
to
understand what
understand what
exactly changed
exactly changed
and why the
and why the
amendments were
amendments were
necessary
necessary
and what it
and what
means
it means
for
for
employers,
employers,
employees, professionals, inspectors, and the
inspectors, and the
overall
overall
economy.
economy.
So, Ambrose,
So, Ambrose,
in short,
in short,
why was
why
there a
was
need
there
to
a need
amend
to
the
amend
occupational
the
safety?
Okay, so Ronald, it's you already hinted a little on it, indeed, that these laws are supposed to be live laws. They're supposed to be kept up to date with the prevailing circumstances, economic circumstances. So you can imagine 2006 to date is more than 20, it's 19 years. We're talking 20 years. A lot has changed. There's a lot of industrialization that has happened now. There's a lot of changes in people's adaptability to the gig economy. There's people that are now doing a lot of working at home. You have people that are more entrepreneurial than before because of the nature of economy that we are now. People are getting more financial independent, aware. So you have almost all corporate people now. One in at least 10 will have something on the side. But what is that? What's the impact of that mini business in your garage, that cottage bakery at your garage? What does it mean on your safety? And does the law cover you up to your garage? So these are things that are definitely not covered in the 2006, not explicitly at least.
Okay.
So there's been need to review the law so that it applies to the current times.
Okay, thank you. So, in 2006,
We got the
we got the
Occupational Health
Occupational
and
Health
Safety
and
Act.
Safety Act.
What was
What
there
was there
before?
before?
And
And
could you explain
could you
to us
explain to
the
us the
environment and
environment
the
and the
regulatory
regulatory
framework
framework
that we
that
had
we had
before this
before this
2006
2006
law came
law
into
came
place?
into place?
So the 2006 law, you can imagine before the British, before we got the independence in 1962, already there was things going on. There were factories. In fact, the statistics show we had about maybe 1,000 or so, 700, 1,700 factories in the country. And in fact, at that time, it seemed like the only workplace that was considered hazardous, albeit there were banks, albeit there were other things that were going on. The markets, there were markets, but
Yes.
at that time, there was the governing law on occupational safety and health was called the Factories Act, signed in 1951. And so between then and now, surely we're not talking factories anymore. At this well, up to 2006. So we're not talking factories only. At the time, there was many other workplaces that had come up. In fact, as we can say, people were more aware to the extent that they appreciated that even as you sat at your teller in a
Yeah.
bank, that even as you as a truck driver doing fuel from Malaba all the way to a depot in Kampala, that was your workplace as an individual. And the people who employ you needed to take caution on how to keep you safe from any hazard that associated with that. So there's a lot of things that have come up. We have artificial intelligence that has come up that is pretty not well, that was pretty not well maybe anticipated to have gone to this level at that time. So between 1951 and 2006, again, a lot of things happened in between there. The extractive industry took a toll on the country. The discoveries had already been made. The political environment allowed for there to be speedier economic development, more industries, more industrial parks. The population grew, okay, from the hardly under millions or 2 million of workers to over tens of millions of workers now. And there are certain facts in there, in that Factories Act that, for example, limited the extent to which somebody needed, for example, a committee, an occupational safety and health committee at the time, limiting it to 20 people. Because at the time, the circumstances figured that a factory, needed to have more than that kind of number. Now things have changed. Like we said, we have two-man workplaces, five-man one-man workplaces. Who brings a one-man person like Mr. Berry, for example? If you run a company that does certification, gives ISO certification to clients, you don't need full-time staff perhaps. But every time you have this gig, you bring in associate consultants, 5, 7, 10 or so. You may be the Uganda Registration Bureau will know you as a one-man sole proprietorship, but you are using 7 or 10 people every now and then. The law was quite not clear on those kinds of things. So between the 1950s and 2006, a lot of these things needed to be. I mean, the name alone, Factories Act, meant that the people that are employing people in the banks, people that are employing people in the markets, had a sort of excuse to give for not implementing good practices in regards to safeguarding of people's health and safety in the workplace. So even that alone was justification enough for some of these things to change. So that's where we've come from.
So Ambrose, from coming up to 2006,
when we got
the law,
are there any international standards, conventions, or recommendations that from which that inspired or contributed to the Occupational Health and Safety Act of 2006 that you can refer to at this stage? Were there any that you learned from or benchmarked from?
So the country, because we're talking occupational safety and health, the country, Uganda, is a member of the International Labour Organization. The International Labour Organization is the UN body in charge of promoting safe and healthy working environments, I could say, for industrial peace in the workplace, for productive work to be promoted in all workplaces, decent work, in other words. If we wanted one word, the International Labour Organization is there to promote international circumstances that provide for decent work. Decent work has many pillars associated with it, but essentially it means that I have a freedom, for example, to associate with people that work in the same area. I have a freedom to bargain collectively with other workplaces for better, not just pay as it might be misconceived many times, but for better working conditions that are more proactive, productive in my way. So the International Labour Organization gives many standards, but two are very key, if all three, for occupational safety and health. One is the Convention on Occupational Safety and Health, Convention 155. This convention mainly put in place a requirement for all member countries to have a legislation on OSH that is aligned to a certain way. So have legislation in place, starting with an arcing policy, an OSH policy as a country, to which you anchor the rest of the other legislation. Have a preventative-based system in place. In other words, in your country. But most importantly, anyway, if I could pick out one thing, have legislation that governs occupational safety and health in your country. The other key standard is the 187 Promotional Framework for Occupational Safety and Health. Now, this one promoted a lot of more getting countries to set up a system. So you have this legislation and all that. What are the vehicles through which it's going to? So you need to have a system in place you have to have a system that now that system has your NIS or fund. So if we want PDCA, if we went from planning to implementing to monitoring and then acting on whatever you get out of, they want you to have at national level, at enterprise level, a form of system that allows for completing the loop. Start with the risk assessment, go on to put systems in place, have the human resource, have the infrastructure, keep updating based on monitoring and seeing what's working, what's not working, and then act on the gaps. So they want you to have a system having both legislation and infrastructure in place, OSHA infrastructure in place, to both implement and then monitor and then act on the gaps. So 187 brought that up. Have a system, have programs in place, programs that put in place objectives, OSHA objectives, targets, and that way you're able to keep. And then that's what, then it requires that you report back to the ILO as a country on how you're doing. What objectives did you set in place, put in place? What targets did you set for yourself as a country in a year? If it is about accident prevention, what were you like as a country before you joined the ILO or before you ratified this particular convention, and where are you at the end of the year? And every year you're supposed to report. So these two key inventions.
So it's like an annual plan, do check, act,
Yes,
but for a country.
yes, but they want you to. So put systems in place that will enable you get that data from Schlumberger, from Total, from Total, but even up to the lowest level, the company that provides cleaning services to that, put in, whether informal, whether formal, as a country, report on how you are improving your occupational safety. So these two inventions are very important.
You mentioned that from the Department of Occupational Safety and Health in the Ministry. How much of this are we after?
No, it's the country already has a system in place. One thing for sure is that at this the legislation, we're discussing legislation, which is for the LO, that's starting point. Because if you're committing yourself, the government has committed itself to say, okay, we shall follow up to ensure that every employer has a policy in place as a minimum. That's already something. Whether there is enough, by the way, the convention on 187, the other conditions that it puts in place is that because you already have the legislation promoted by 155, so now in 187 they're telling you have a form of inspection, have a form of enforcement, because that's very important. So we have these things in place, but of course whether it trickles down into reality up to the person who cleans your office is another story altogether that the government definitely cannot do alone. And I know we shall be talking about how the private sector and government can be collaborating to ensure that these very nicely documented things that we're now discussing actually relating. Because the outcome is I want to be a productive individual so that the little earning that I get is to actually use to improve my livelihood. It's not about, we should not measure OSH only at how many ISO certifications you have as an enterprise, how many of the documentation are in place, how much you've adopted AI in your systems. We want to know what is the impact of all those things at the end of the day. The story should end up in a more productive individual whose livelihood is improved and is safeguarded. So they live up to the life expectancy. That's the point that all should be looked at from, not the policing for helmets and all that. Okay, so you run around Ambrose putting on a helmet, but at the end of it all, what is that impact on me? And I think sometimes it's a discussion for another day, but that is some of the reasons why maybe a lot of us don't often appreciate what we're being told to do in the workplace in regard to occupational safety and health, is because we don't link a safe workplace to my livelihood. Back to, I come from Masaka, for example, all the way down to where I come from, the deep in the village. So essentially, these are, I've brought it from international labor standards all the way to that person that is working for you, working for me, working for the government, or myself as I work for the Department of WASH in the country.
Thank you. And
we have talked about the Uganda Law Reform Commission, but before I come to that, you hinted at some point that as a country, we have OSH policy, and then we have the OSH law, and then we're supposed to develop enabling regulations anything that makes it implementable. Could you speak to the OSH policy of the country? Does it exist? What does it look like? How can we access it? What does it say? Speak to the OSH policy.
Okay, so in since as we are now, the country has a national employment policy. 2011, since
National
2011,
employment,
a national employment policy.
okay.
But the way labor administration is structured in Uganda, or now let me bring it down, is that the mandate is given to the ministry in charge of labor to take care of our labor affairs or labor working conditions wherever we are. So the country has divided the Ministry of Labor into three directorates that pertain to labor administration. One is employment services. This department is the one that caters for ensuring that when I get out of the university, I have the right skills, the soft skills, for example, to get into that work. You will appreciate, Mr. Betty, that definitely many times graduates are not exactly ready for that actual workplace. Okay, the expectations are high or lower. What do I do? How do I answer questions in interview? Are not things that the curriculum yet gives in many of our institutions. So there is a department in charge of that, and whether they are preparing you for Uganda or they're preparing you for international markets. So you have internal employment, you have external employment. That's one department. You have another department for labor, industrial relations, and productivity. As you can imagine, industrial relations, industrial peace in the workplace. You want people that have freedom to associate. The promotion of minimum wage. Mr. Better, later on, don't ask me if we have a minimum wage in the country. It's a difficult one. What is the workplace? What are the stakeholders, starting all the way from the government to the private sector, the employer? What are you doing to ensure that the worker produces those units you expect per that particular worker? So labor, industrial relations, and productivity, and also taking charge of ensuring that there is enough supply of engineers. Okay, there's enough supply of doctors, just enough, not an over. That level of planning is for the Department of Labor, Industrial Relations, and Productivity. And then thirdly, we have this Department of Occupational Safety and Health, which is a sort of almost cross-cut everything that you can think of. How safe is the workplace that you have given to me as a worker? If I'm a self-employed person, what am I doing to ensure that where I'm working from, I come safe into that workplace and get out and go back to the home safer, or at least as safe as I came, and not even have any negative impact on the people that I am looking after or people that we are living with in the workplace. So those three things are what make up occupational safety and health, what make up that function of labor in the country.
Okay.
So yes, essentially, that's how we are structured.
So where is the OSH policy now?
So the OSH policy, so that is why you have a national employment policy. Because employment, if we could, we could call it a national labor policy.
So it's a national employment policy
that has all these three key
in there you'll find something
on labor, industrial relations, and productivity, OSH, and on employment. Like I said, unfortunately, the National Employment Strategy 2011 didn't go to the next stage of making a strategy. As you know, a policy is this whole high-level document that gives the government's commitment to what it wants the country to go towards, okay? What kind of jobs are creating? Are they decent? What kind of pay are they giving? What kind of conditions do you give to investors to ensure that they're also encouraged, incentivized to stay and invest more? So there was no strategy that was put in place, and that is why currently, through support of different stakeholders, donors, using the country's MTEPs on its own, the country has already submitted to the cabinet for approval a national employment policy, which along with it also has a national employment strategy. In there, you have an OSH strategy. In there, you have a labor strategy, and in there, you have an employment strategy. So in there, for example, if it's OSH, OSH will have a full section. Before the cabinet agreed or guided us, we had designed an independent document called the National Occupational Safety and Health Policy. Okay. But because there's so many documentation in the country, the cabinet secretariat eventually said, you know what, you are the same ministry. You can have a consolidated document. The issue is you want information to appear somewhere. whether it is independent in a document or whether it is a section over another document, whatever it is called, it's still something that can be benchmarked on to take whatever mandate you have. So we agreed, and as a ministry, we consolidated all those three departments into this. There is an OSH policy, but it's not an independent document. It's only part of a larger national employment strategy.
Thank you.
Thank you. Thank you.
Tell us
Tell
about
us
the
about the
Uganda
Uganda
Law
Law
Reform
Reform
Commission.
Commission.
How has it impacted on the OSH Act? What has been their contribution?
So in the journey that you initiated our discussion on, from Factories Act to 2006, Safety and Health Act 2006, under the Ministry of Justice, you have that Uganda Law Reform Commission, which is an independent body that is responsible for consolidating the principal laws of the country. So you have every sector coming up with all kinds of documentation, but over time, whether the sectors update or revise or repeal their laws or not, there is this Uganda Law Reform Commission which is supposed to look through that 2006 law and see the language you used in 2006. Is it still applicable? Okay. Did will and shall mean something different that now you want to ensure that no, where there is will, we want it to be shall. Those things that don't necessarily cause for a total reform, but call for a few edits and other things that pertain to the law. So Uganda Law Reform Commission is does that every 5 to 10 years
On every law.
on all the principal laws of the country. And in 2023, it published a red volume, a new set of principal laws, but not revised from the technical perspective, but from the perspective that we have just indicated. And so a few things changed. For example, I'll tell you that the section on commencement, on any law, there has always been a section on commencement. This law shall commence from this date, blah, 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 blah. But that information was a repeat, I think, from the perspective that Uganda Law Commission saw it, because there was a date, there's already a date on the law. So I think it saw that as a redundant. So it took out all laws that still had the section on commencement. It took that out. And so you can already see the numbering.
So now what do we then count as the date of commencement?
So now there is a date that is actually written on the law, which shows
the name of the law.
There is a precision on that, like how you write a letter, from and to. So you know that that's the date that it took effect. Yes, and also the president signs and assents on a particular date, like how we know it is 10th April 2025. There is a page where that signature is. So information is there. So I think it felt, among other things, I'm not a lawyer, they thought that section was not needed. And a few commas missing here and a lot of other things. But I'm talking about the OSH Act now. So they changed it from the nomenclature changed from Occupational Safety and Health Act 2006 to OSH Act Chapter 231. For a law to be considered an independent one, it must have a chapter number.
OSH Act
Cap 231.
Cap
231. You know, you know when they produced that volume having all the principal laws of Uganda, until the Uganda Law Reform does, even laws that had been repealed will still exist in the old volume. So now the new volume also takes care of that, taking out all laws that are repealed, and that means that maybe the chapter numbers that were there now become redundant. They may give it to another. So the chapter numbers also subsequently change. We were a different chapter, now we are chapter 231, just like other laws. So the viewer needs to know that actually the OSH Amendment Act 2025 revised the OSH Act Cap 231. So you will see that the changes in some of the sections we refer to. If you went to the OSH Act 2006, you may be confused because the numbering changed once we get into the OSH. Because by the time the Parliament took on this particular Amendment Act, the Cap 231 2023 had already come into play, and so there's no way they could refer to revising a law which was no longer in place.
Wow.
So that's what Uganda Law Reform Commission, and we are hoping that unfortunately now, therefore, the reader has to have two documents side by side: the OSH Act Cap 231 and the OSH Amendment Act 2025. Because some things changed in the CAP 231 that are not mentioned in the amendment. The amendment only mentions the things that changed. So somebody has to read the two. So until the Uganda Law Reform Commission does another revision, another volume, so that we have one document consolidated. For now, I don't want to say unfortunately, but the burden is on all of us users of the law to have those two documents.
Have those
Yes.
two.
So,
Okay, so
when I'm
when I'm
referring to
referring
the
to
post
the
law
law,
country, what should I
what
say?
should I say?
Which one should I
Should
pick
I
when
speak
I'm
when
referring
I'm
to the?
referring?
So there is only one law on the on occupational safety and health in Uganda, which is called the Occupational Safety and Health Act CAP 231. Only. The Amendment Act is only but a part of the other one.
Okay.
There is only one law. Yeah.
Okay.
All right, thank you.
Let's go and
the
the OSH Act
CAP
CAP
231.
231.
Let's discuss now what
what
changed.
changed.
Yes.
What
things
changed
changed
from
from
2006 to
2025.
2025.
Okay.
Please walk us through some of the
key
key
areas that we need to be
we need to be
aware of.
aware of.
Okay. So you will allow me to read a few things that we don't, and we shall go in order of the actual act.
Yes.
So number one, the section 1 of the law was changed because it had definitions, and over time there's been a bit of gap seen in the fact that risk assessments were never defined explicitly. So stakeholders looked through the different definitions that have emerged that need to be clear to people, and so a few were placed in there. Safety and health audits, safety and health risk assessment, among others, were definitions that were introduced in that. Section 8 was also revised on prosecution. And I remember I told you some of the reasons that some of the reasons why we had to change is pressure from having now to adhere to the Convention 155 and 187. These conventions actually put a bit of effort, pressure on the countries to prove that they're doing enough to enforce the provisions of the legislation. So that law was a little bit confusing because in Uganda, the only body that is allowed to prosecute on behalf of the government is the Directorate of Public Prosecution. But that particular section was given powers to, erroneously given powers to an inspector like Ambrose. Those are the kind of contradictions that we talk about. So now that law clearly indicates that Ambrose, if I found a certain employer in contravention of a particular section of the law, I found that you're not registered, or I found that your environment is noisier than the Environment and Environment Act noise standards gives you for a particular nature of workplace, let's say factory.
Yeah.
If I measured and we found it higher, and I found those contradictions, I warned you, gave you a provisional order, for example, to close that particular area until you work on the equipment from the engineering perspective. We don't only, as you know, we don't only look at the PP and all that. So if we advise and ask you to modify the equipment to make them less noisier, install anything that you need to install, silencers, etc., so that these so that the PPE really only reinforce where you are not able to still stay within the standards after doing that engineering modification. Then we will tell you that, you know what, don't let these workers be in here for more than, say, 2 to 3 hours consecutively. Okay, so if we find that you are against that even after the first warning, we can prosecute you. But now Ambrose cannot, from the law as it was before, up to 31, I could simply go file a case with the nearest magistrate and take you on. But this regards, no, you can only do that in consultation with the DPP. So that's clear.
Okay. Before we move to the next one,
Ambrose,
you tell me,
have you
have you
prosecuted
prosecuted in the past?
About how many
About how many
prosecutions
prosecutions
we have in the year for employers who are not compliant? Do we have any?
So we've not, the country has been, because of the culture of occupational safety and health, the country, I could say the department has been very lenient. And most of the times where we are close to prosecution, eventually the employers request that we settle it out of court. In other words, they implement right away. The moment you get to the level that they see the next stage is prosecution. They've been served, and you know, you have a prosecution officer taking charge of the file, and etc. Then realize, things are serious. Please give us a week. And because for us it's about improvement, usually we settle for that because it's bringing
what you want.
It's what you want. So we don't. It's not about how many cases we want to be able to report to the ILO. That we have. So the labor officers do that job a lot because, by the way, a labor officer is given mandate under the Employment Act to they are like the first court. Labor officer can go to the level of setting you a penalty. Labor officer can go to the level of awarding compensation. They've been given that, and it's only until the employer or one of the parties finds there is only objection that you can go on to the magistrate's court, the industrial court, if need be. So we've not had to do that so much because we really want to promote compliance, and as I've described, I'm not able to tell you. However, from the other labor administration point of view, the cases are many. In fact, there's a whole management information system from the industrial court which would show you how many cases are going on, either for uncompensated injuries or unfair termination. Somebody refused to work in an environment that was hazardous to them. They reported to the commissioner, and somehow the employers find out that this person is a whistleblower, so they start to prosecute them in that way. There are all those things that are going on in the industrial court that might not be out there. But yes, in that respect, in terms of industrial peace and other aspects of labor administration, prosecutions are going on. From the OSHA aspect, we've been slow, but we want to change that culture. We want to change that culture because, number one, like I say, the international standards demand it. They want you to set penalties that they know bite and that you actually apply. Because without that, I mean, even as a country as progressive as the UK countries, they will tell you where they started from is they had to bite. They had to bite to get to the level where we think now, in fact, employers, almost like in the Norway, some of these model countries, the oil and gas industry, in terms of safety, where they've gone to the level where people are doing voluntary compliance. People are out there innovating means of keeping workplaces safer than, as safe as practicable, which is a culture which we are quite still far from. Among the reforms that were introduced, as you've seen in the OSHA Amendment Act, is to make sure that we do a bit more. We get a bit more of a whip so that we get the attention that I think OSH deserves in that line.
Okay. I think let's proceed to the other change. We are talking about, I think, employer duties.
So we're talking about employers' duties strengthened because initially we've had that word, and those are the phrases that we keep being asked, what does as far as reasonably practicable mean? And you might even be in a better place because of your experience with the oil and gas industry. Because these words, this word is used a lot. I think for the oil and gas industry, is it ALAP? It is as low as reasonably practicable. It was meant to be in the same spirit in this law of as far as reasonably practicable. Now, given that at that time the British had that perspective that employers are somehow willing to keep their employees as safe as it is, because you look at it, they should be looked at it from the perspective that an unhealthy worker is, But unfortunately, over time, the law is being tested, and I think these words leave things on a slippery ground, because an employer will simply tell you, I have done what is as far as reasonably practicable to me, since you've not necessarily put a prescription on what this ALAP is. And I don't know, we don't have the time for you to explain how it is working in the oil and gas industry so far, how it has been tested. If you think you can describe it in 2 minutes, I would be very happy for viewers to listen to how the oil and gas industry has kept it, because it's an industrial accepted jargon. ALAP is accepted. In this other aspect of general safety and health, we failed. And so we were advised, check it out and let the employers do what they're supposed to do.
Okay, I guess before we proceed to the next one, so at what point does the employer say the controls are put in place are enough? Where would they stop now? Because, when it comes to
you can't eliminate all hazards from the workplace, but the best thing you can do is to reduce the level of the risk. And previously, we were reducing it to as far as what the practice was. So now you remove that phrase. So now, to what level should we reduce the risk? That's the question. When we say we have done enough.
So after taking away this word, then again from the legal perspective, they ask the same question, and so that's why later on we'll see a section that now was introduced on the mandatory safety and health risk assessment, which are supposed to be submitted, and these are supposed to be done by safety and health practitioners, okay, and then submitted to the commissioner. Of course, these would be hundreds and hundreds of reports, but key is done by a licensed safety and health professional, just like we have with NEMA. NEMA will have those 10, 15 environmental inspectors in that office looking at all these impact assessments that have been done. But really, the important thing is collaboration with the private sector, who are regulated, who you trust that, okay, if they do bring this safety and health risk assessment, all the measures, the management plan that they have put in place is fairly something that you can rely on. That if this employer does implements the measures that have been set out in this safety and health risk assessment report, they will have done what is mandatory, what is satisfactorily sufficient. Yeah, that I could answer it in that way.
Okay.
Yeah.
So the next major change that you are going to allude to is on policy. Eh?
Yes.
You're saying all employers, regardless of workforce size, must now develop and implement policy. So just talk into that and try and defend why now a workplace of one or two employees deserve to have an policy.
Yeah. So like I said before, the issue was that the predecessor laws, Factories Act, had put the cap at 20. Because it was imagined that many factories, perhaps individuals were the level of sophistication of a factory that had less than 20 people at that time was deemed not to present hazards that require to be documented and have all the systems put in place, which is not necessarily true, like we've discussed today. With the kind of economy that we are, with the kind of level of mechanization that we have, you have farms that can now be run a full square mile that can be run by less than 10 people because of the level of mechanization. If you have drones that are doing all the monitoring, you have drones that can now actually do irrigation, you have drones that can fertilize, etc. You don't need as many people. But that definitely does not take away the level of hazard of that nature, because you're still handling chemicals, you're still handling machines, you're still handling tools. So it should not matter whether you're a one-man farm, whether you're a one-man liquid soap making factory. The thing is that hazards are in place and you should do whatever it's case, because unfortunately, when a wrong happens in your garage, an explosion, it is very unlikely that it will not escalate to the community. There is a very high likelihood that it will escalate to the community. So we cannot let you be selfish. Even if you wanted to kill yourself, you need to protect the others.
Before we move to the next one, what is an policy? Is it that half a page, one page that you find at the reception?
Yeah.
What we talk about
policy? So that it also does not confuse people to think, okay, now I'm a two-man person, I have this consultancy, what do I need to have these documents that I see? So an policy, and again, the 2006 law is clear on that. The schedule 2 gives you, 2 or 3 gives you an outline of what an policy is. It consists of 3 major parts, and we again captured this, and it's been applicable for a long time. That statement that certain levels of organizations which have lived that stage, that statement of intent, or what actually many people think is the OSH policy, is just a single page, a commitment signed off by the accounting office of that organization to communicate in a few lines their commitment to keep the policy. Please, definitely, that is a third of what a policy is supposed to be. Now, the other second aspect of the policy is supposed to be the system that you put in place, the organization. How are you organizing to implement that policy? those statements that you've put as UNOC, those statements that you've put as DOSH, those statements that you've put as OPM, then you use government bodies, because these laws are not only supposed to be used by the private sector. So that statement is only surface, it's only the tip of the iceberg. What we want is what systems have you put in place to ensure that it's actually implemented and known up to the last level. Okay, so we want you to have that statement, but the second stage should be our in the PDCA that we talked about. The aspects of risk assessment should actually be done. Are you what are you basing those safety procedures on? Are you I mean, to what level do you? It's only risk assessment which will tell you whether you actually need an independent risk assessment procedure, whether you need. There are companies that are at the level of needing an independent job risk assessment procedure. Okay, different from the generic risk assessment that you're going to be doing every 5 or 10 years. Different from a job risk assessment. So depending on the level of sophistication, and you cannot determine that all of that can't be on a half page, and it cannot be determined from you need to do a risk assessment. So our PDCA is actually, if I could say, is the OSH policy. An OSH policy should have all aspects of the planning, implementing or doing, checking and acting on the gaps. That's what a policy should be.
So just repeat this because
so you're
sure.
saying
So you're saying
that one
that
page
we have
most of our
receptions
is not the
is not the policy.
It's only a part of the
It's a part of
policy.
the
It's only a part of the policy. You've gone only 30% when you only have that.
All right,
let's proceed with the other changes you wanted to discuss.
Yeah, so there are other laws, things that have changed, for example, in regards to safety committees. Again, this is part and parcel of the other 20 number of workers thing that now, because of the level of saturation that we are getting into, the types of economy that we are evolving into, it should no longer matter how many people you are. So now an inspector who comes to your workplace that has 10 people will get you on the wrong side of the law if you don't have a safety and health committee in place. So there are regulations that are part and parcel of that particular aspect.
Okay, the next one.
So the next one was, it's still under 15. That section 15 had 15A now introduces what we already talked about, licensing of safety and health practitioners. Okay, so you will see that now we expect that having tested this law for the last 20 years and realizing that there is no way. The other thing that I didn't indicate in the instance is OSH is not decentralized as a structure in terms of human resource. It's not, the function is definitely decentralized. The government took upon a decentralized approach. It means that the services, of course, are decentralized in every way. But the actual people are not decentralized, like how you'd have engineers, like how you'd have HR, how you have accountants, how you have procurement officers. So, and there is no way the government will ever employ enough number of inspectors to cover this country. So this particular, and because also the government is supposed to concentrate on the policy aspects of this discipline, we need partners out there. And so that is why stakeholders, this is demand. By the way, these reforms are always demand driven. So this particular demand of licensing safety practitioners was demanded from the private sector out there. The different people that are out there say, you know what, we need to work with you. You need to work with the private sector. And the government agreed. So now regulations are being put in place or being drafted. Right now, they've already gone through the initial stage of internal as the Department of OSH and as a ministry. They've been discussed. The next level will be to bring them out to the public and the different institutions so that we see how we can take on the practices that are helping other countries, Kenya, Tanzania, South Africa, and other countries in how to regulate or manage safety and health better in a country of more than 10 million workers or employees with a structure that allows for hardly 30 inspectors at the center. Yes.
Okay. I see it here. The minister shall make regulations providing for the registration and licensing of safety and health practitioners.
Yes.
And then it goes on to say a person shall not conduct safety and health risk assessment,
Yes.
safety and health audit, or any other assessment or audit required under this Act,
Yeah.
unless the person is registered and licensed by the Commissioner as a safety and health practitioner in accordance with this Act.
Yes.
Now, someone called me. Then it talks about who the person who commits this is liable to an offense, conviction, fine. So someone called me and they were afraid of being charged this 1,000 currency or prison for 2 years. And they're asking me, okay, what do I need to do to license by the commissioner? Do I need to call the commissioner right now? Now, doing this
Yes.
Could you speak to how me as a professional can stop doing risk assessments illegally right now?
So now the weight is on the government in terms of legislation, because the president has assented and agreed to has allowed the minister to come up with regulations that stipulate who qualifies, where should they get that qualification from, shall the country acknowledge a qualification from OSHA, Occupational Safety and Health Administration? Will you recognize NEBOSH? Because the country does not, what will you recognize? How many years of experience will take you to what level of practice? Can a government worker do the same? It's all those nitty-bitties are supposed to be contained in regulations, which, like I said, now the weight. So until regulations that put in place the actual requirements for you on how somebody can become a safety and health practitioner, can become indeed licensed. Unfortunately, we will still have to battle with the idea of needing to work together with the existing practitioners, by the way. The department works very closely with the Safety and Health Association of Uganda, which is not legally existing as a body that licenses practitioners. But in one way or another, if somebody said they are a member of an association which is known by the government, there is a little bit more trust in there. But for now, we don't have any legally working safety and health practitioner until the regulations are approved.
Okay.
Yeah.
Okay.
However, it does not mean that workplaces should not conduct risk assessment, because even before this reform, an employer is expected to ensure that they monitor, and you cannot monitor something that you have not assessed.
All right. Let's speak to, you mentioned the Safety and Health Association of Uganda. I'm wondering, they had contribution or are they expected to contribute to the regulation that the minister is developing? Because I think
they'll have a lot to say and contribute on how this registration and licensing of professionals work.
Actually, the reforms that we are discussing today, that this Occupational Safety and Health Amendment Act 2025 were contributed to by the private sector heavily. The parliament, we have the committee called Gender, Labour and Social Development Committee. So in other words, every ministry has a committee in parliament. Because as you hear PAC, you hear COSASE, we also have a gender committee, in short, which discusses all policy-related matters that are coming from the gender sector. So that committee, once we presented to them, we submitted this to the Minister of Justice. Minister of Justice sent this to the First Parliamentary Council, and so this committee took interest into the amendments that we are proposing, and they said, okay, where are these coming from? And they said, no, these have been contributed to by this representative. I said, no, we don't believe you. Show us a report that you've consulted them. Said, here you are, but is this all they had to say? So they actually went on calling cohorts of people, starting with, I could even mention a few people. I remember Mr. Kajuka Edgar was among the people that went to that committee, before that committee, to present their opinions on what the reforms are. There's a Dr. Sechimpi, he's a renowned occupational health specialist. So among other institutions that we claim to have, the academia were also taken in there. So the process is usually as consultative in nature as possible. So the association, in this way, we presented the association represented by a few of those individuals, but said that this was speaking for the private sector. And so the association definitely contributed to these reforms and continues to contribute to when, we are banking on this association, by the way, and any other association that will come up to bring professionals together to be able to churn out practitioners that we will vet using the regulation. We're not going to go out there scouting for practitioners on our own. Even I, Ambrose, if I retired from the government 2 years from now, or if I wished, I should be able to belong to an association from which now the government should trust and say, okay, because now right now we are the association, the SHAO association says or reports a 500 member database. When we have that information, as we're defending, because one of the things that the parliament also asked, so are these people there? Okay, are the practitioners talking about there actually, or are you simply putting out something, and then before you know it, we're fidgeting. People are going to come from Kenya, UK, to enter into a market. I said no, these members are there, and who can prove it? An association like that with a database like this. If you want data, the data is there. So we are banking on these associations, SHAW and similar associations, to be innovative, have management information systems in place that can be looked into for data and analytics, so that we are ready. We are both ready to implement these reforms.
What's the next key change you'd like to discuss?
So we have reforms on health surveillance. Again, like I said, one of the standards that I didn't mention from the ILO that we are hoping to ratify is the 161, Occupational Health Services. As you know, it is one thing to put all these systems in place, worry about PPE, do the risk assessments, all these, put all in places of the OSHA infrastructure that we're talking about. But at what point do you appreciate that these systems actually working? You want to be able to understand that Ambrose went in or came into Ronald's factory, drinks factory or soap factory, with this baseline of health. I came in breathing like this state with this kind of sight. Then along the way, monitor health surveillance is about understanding my situation as I come, hoping that you did a health risk assessment to understand which jobs require which kind of people. So when I come in and you conduct this pre-employment medical organized examination on me, if I am pregnant, if it is a female who is pregnant and the job is supposed to send them out to the field, that's already a system put in place to stop you from sending this 4 months pregnant lady into the field, for example, because they may not be able to get the due attention that they need. So Occupational Health Services is trying to make sure that we link the putting in place of systems at enterprise level with the health management, with the health sector. We're talking about wanting to get data. Enterprises will come up with this data. When enterprises will want to, the oil and gas industry, the nuclear industry, the kind of tests that, for example, even go to the civil aviation industry, the kind of tests that the civil aviation industry wants to perform on its divers, the marine team, is not your ordinary test or the liver function. There is something they call how the body is impacted on when they fall in, when they dive into that water, how much time they spend under there, and even the oil and gas applies with it. But who's going to do these tests? And many times the government has gone to these IOCs, company has gone to the civil aviation. So who is doing these kinds of tests that we expect you to do on the liver function and that? But where on earth do you expect us to? Your health sector is not ready to get it. We've had foreign companies asking us, that's okay, you want us to do this, but the test you're talking about, as far as we know, can only be done, for example, in South Africa. We are trying to set the country, that standard expects the country to set up a holistic system. Demand pre-medical examination, demand routine, but also let occupational health or occupational medicine also be promoted, so that we have very few. I don't think we have more than 5 occupational physicians in the country, for example, and yet we're talking about developing health surveillance plans. Okay, so a lot of this is what this standard is putting the country under pressure to make sure that we put.
Wow. All right, Ambrose,
take us
take us
through the
through
next big
the next
change
big change
and the amendment.
So the next big change is on the section 20 of the Act Cap 231, which is on monitoring of health. So initially, the law required pre-employment medical examination and periodic, but was putting a condition that that should only be done in workplaces where workers are exposed to hazardous conditions. Again, that was a little bit.
So are there
So are there
workplaces where
workplaces
workers are
where
able
workers
to
You
are
get
face
it.
exposed
So
to
hazardous
hazardous
that
conditions?
unclarity is what has been making some employers feel that I don't know the kind of environment I am in. If it's a bank, for example, if it's a microfinance institution, if it's an office, I don't have anything that poses threat to my work. So besides just explaining, we thought it would change it and put the onus, put it in a minute broad. So now it reads, it's a requirement for employers to monitor health of workers. Okay, so, and that is what health surveillance is about. It's being called health surveillance because health surveillance is about tracking, picking my baseline medical information as I come to work for you, or I join.
Yeah. Mm. 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 Okay. Right. Thank you. The next change. Mm. 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 Okay. I think we need to talk about citing, and this is something I think you highlighted a little bit earlier, but we can expound a bit more here. Are there any complexities in how the law is cited? Mm. 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 Okay. 15.1, so that it connects, the example is clear for us, for the professionals. So 15.1, minister shall make regulations to provide for the appointment in prescribed cases of safety representatives. Or maybe, I think it's 16, it's 16.1. That is 15
in the cap to 31. Initially, it was one number up. So
you're confusing me. I have the also. So there's a new document now called Cap to 31.
Cap to 31. So there is a new document called
Okay. Okay.
numbers that have changed.
I think this is a very, very big point for people who are consuming this content now. You need to find the Occupational Health and Safety Act 231. It's a new document,
Yes.
which is different from the Occupational Health and Safety Act.
Section 15 of the Occupational Safety and Health Act 231. And to make it easy to understand, I will put in brackets, amended by the Occupational Safety and Health Amendment Act 2025.
Okay.
So that now you make it.
Okay, which is 13 in the old, before 12
was also changed. You could pick on 19. 19 was not touched. So whether an assessment implies continuous exposure to dangerous inclusion with the duty of employer to suitable alternative employment. In other words, the aspect of which makes it illegal for you to write a report on me that I refuse to work, I refuse to give me my wage, because I refuse to work in that factory, because there is a leakage, where there is even some ammonium and I can even smell it. Today, until that is sorted, and my colleagues were not stepping into that particular work again. If the boss gets to that level whether they can justify this rulings, and even if it's an inspector, that report came through from the department.
All right, Ambrose, we have discussed a lot about the law and the changes that we have had in 2025.
So as we come to the end, what does all this mean for employers? Yes. What should employers be thinking? How can they ensure that they begin to move towards compliance? What's the implication?
So because there are some new reforms that have been created, some of the changes are really just to emphasize and to enhance compliance, like these committees and all of those things have been required anyway, at least for the people or the employers that have more than 20 workers. It's not going to be a new requirement, but this is only to re-emphasize. There are also totally new requirements, okay, that have been introduced to enhance safety and health in the workplace. So ensure that if you don't have a person that advises you on occupational safety and health before, that you get one. Have somebody responsible for looking after the matters of safety and health in your workplace. What they will then need to do is look through this law and draft out some kind of matrix. It's the closest you can do now. Draft out a matrix, go clause by clause as we've gone through them now, because this particular presentation, for example, will be available online. It's information that we can use as public once we put it together and put it out there. So it can help you to not to exonerate you from having to read the Amendment Act and the OSHCAP to the one, but to give you a summary of what section has changed and what it means for you as an employer. Now you need to do annual audits. Now you need to do risk assessments. Now you need to develop health surveillance plans. All of these things, as a government, we will not expect them to start right away in your workplace, because it may be too much, especially for those firms that have been having under 20 people, and so there are some regulations that you've not been meeting, but we'll expect you to have a plan in place on how you will comply in the short and long run on the especially new reforms.
Okay. Thank you. How about the workers themselves?
Yeah, so
what are the implications for workers?
The beauty that it is for workers is that they should know that the law puts them at advantage. As a worker, the law is put there to protect you. So make yourself aware of what is contained in this, especially in regards to accident notification. Because once this law now means that even before, but it's now more explicit, that if you have observed an accident that has happened in your workplace that seems to have gone silent, you've not seen any labor officer coming to do an investigation to see that the employer is meets their side of the bargain, if it has something to do with compensation, if it has something to do with correcting and preventing recurrence of such incidents, you know that you can walk to the office of the commissioner and report the same. We have an occupational safety and health management information system, which will hopefully be by the end of this financial year, June 2026, should have created notification module where even we can have free SMS notifications that even on your mobile phone, whether it is a smartphone or not, you can type a certain digit and put out a notification of an accident, a notification of an injury that you feel has not been responded to. So for employees, really the most important thing is for you to make yourself aware of these kinds of rights that you have, so that you do your part. Also, of course, the most important thing is to do as you are told, as long as it is safe for you to do so. If the rules and regulations that have been put to keep you safe and healthy, ensure that you abide by them. Because the implications for you being caught up in the mix of an accident, where it can be proved that you didn't do your part as a worker.
Okay.
Yeah.
Now that you mentioned incident reporting, could you distill and summarize for us what what the law requires as far as reporting for workplace incidents is concerned?
Okay, so again, I'm not able to give the details because, again, there is a weight on the department to come up with regulations on notification of accident and injuries and occupational diseases, since it's now explicitly within the Amendment Act. So again, these are the laws that are in line. Before the end of this financial year, we should be hearing Parliament talking about these regulations, so that even before the end of the year, maybe they are approved by this 12th Parliament, hopefully, because the Parliament has been demanding since 10th April 2025 to date. What have we churned out? So in regards to notification, I think until we are ready to consult the public is when we are able to tell you, in how long should you notify an accident, what are the reportables, what are the just recordables, what can I report, what can I not report, how long should I keep the C6 within the code. They will stipulate along all those lines.
All right. And what do all these changes mean for OSH professionals?
Well, again, the OSH professional, remember, you are like the consultant of every single employer out there. They were expecting you to be aware of what's going on. Keep yourself, you're closer to the Department of OSH than any other person. Feel free to even advise where you think information has not been passed out well enough. You're the people that are responsible for, or have a good level, a good hold onto sensitization and publicity in your areas of operation, whether you are employed, whether you're in the private sector, self-employed. You have a good hold on bringing people together to sensitize them. Invite the department, invite the ministry to do these things with you, so that we can explain these things one by one. But also look forward to preparing yourself with, associating yourself with an association, because trust me, I can give you a snapshot into what these regulations are going to have. Definitely, no one can be brought into licensing if you are not associated with something.
Okay.
Not engineers, not doctors, not lawyers, all of them have to first be associated with a certain association before you can go legal. So ensure that you associate yourself with groups with similar beliefs. I don't want to sell any existing association, but like I said, it can be that one or any other. So that we prepare for that stage, and also be prepared to make input once regulations are ready for consultation.
Safety professionals, do you hear? You need to be associated with an association before you can be considered for certification. So this is something that would be very, very good for us. So take note and act accordingly.
To organize.
Organize yourself. This is a big one for safety professionals who would like to practice in Uganda. Okay. What are the next steps for the Department of OSH? I know you have been actually referring to some of them, but this is for you to distill what the department will
what's coming
in the next 6 to 12 months, or maybe the next 1 to 2 years.
2 years. So one of the most urgent things is to bring out these regulations that are pending, that are holding on. The regulations on practitioners, regulations on audits, and risk assessments are definitely something that is holding back progress ever since this Amendment Act was approved. So the next 6 months to 1 year, we're working hard in there to ensure that we bring these out.
So how many regulations can we expect in the next 1 year?
There's actually 6 of them.
You think 6 of them will be passed?
The 6, not, this is calendar year. Our plan, it's possible, because regulations don't have to go through the rigorous processes like an actual act. If all goes well, even this calendar year, by the end of the calendar year, or by the end of Q2 of financial year 2026-2027, some of these regulations, first aid committees, practitioners, audits, notification of accidents, and then we want to also review, there's been demand to revise the regulations on workplace registration and statutory fees for some of the industries, because going on to promote for informal sector, there's pressure to provide more for the informal sector to be formalized. I think that's one of the jobs creation agenda for the country.
All right. Okay. Do you believe the amendments position Uganda competitively in the industry, or like slow business?
No, it should be that we have no choice. We must admit that a lot of our projects we have support from development partners. World Bank is one of them. They have a whole jobs first agenda which speaks to everything that we're talking about. So as a country, we have no choice. Number 2, our NDP4 that is now running this financial year and ahead. His Excellency, for the investors, His Excellency, this tenfold development strategy, growth strategy that we're talking about, promoting ATIMS, agro-processing, tourism, mining, and then the science, or ICT. Those 4 sectors, there is no way you can go into that level of industrialization, because you can say, apart from tourism, the rest of the things like agro-processing, you're talking industrialization. Mining, you're talking steel industrialization. ICT, AI, you're talking industrialization. You cannot get there without looking at the fact that what we want is to create decent working environment for livelihoods to change. The key mission of all of the strategies that we're talking about is sustainable economic development which improves the livelihood of an individual up to the last grassroots root. So without you creating a decent working environment, you cannot achieve the other. Because either I'm making money, but I'm spending all the money on my health. I'm making all these savings throughout my NSSF. We've formalized my company. We are saving NSSF. But once I get access to that NSSF, I have to spend it on physiotherapy for the rest of my life. So at the end of it all, without creating decent working conditions, we will not have achieved those the tenfold growth strategies that we're looking at attracting more funding from development partners, attracting, as private practitioners, attracting more funding from not just World Bank, but other interested, UN agencies that are looking at putting money into things that promote health, that promote improvement of livelihood. So definitely these strategies that we're going through are taking us part and part to achievement of our overall NDP4 goals and all our strategic strategies that we have, strategic thoughts, yes, and plans that we have.
All right, thank you, Ambrose. As we come to the end of this show, Ambrose, is there a question or a point or something that you felt you expected you would be asked but has not been asked that you'd like to talk about?
I think that we've covered quite a lot, and I know the employer out there is probably, that last bit that you brought, is it worth the investment? Is there business value in investing in OSH? Is probably a topic that I hope that Mr. Perry, you will once bring somebody on this podcast to discuss the business case for investing in OSH. I think a lot of what we are having in trouble with investors and employers, that's what they are lacking. How do you relate investing in OSH directly to productivity and making your business more profitable? I think creating a business case for OSH is something that is sensitive. It can even cause an argument that may not easily end, because at the end of it all, it should not only be about how much money I'm making from investing into OSH, but we can make those arguments though at some point. But
this is what I think. Right now, because
the laws and regulations are being developed. They have to be developed and then implemented. Right now, in my view, it's hard to make the business case. For example, let's think of the petrol station. You're saying that those people handling that fuel every day need to undergo annual tests, annual medical surveillance, okay, to find out how much of whatever chemical you're touching is maybe impacting some of their body organs, okay, and their cells. Now, those tests may actually cost $1 million shillings to do per employee, but these employees also pay 100,000 shillings. Now, because to the employer in this example, there is currently no direct relatable consequence to not doing this test. And also, this employee maybe will work there for 1 year and they'll be fired. There's also no way for them to come and say, look, when I worked 1 year at your place, because that consequence back to the employer is not immediately there. So when you try to do a business case, you will not have that part of consequence where there is a fine of 500 million, for not doing it, or for the health consequences that your workers have suffered. So I think
it's
there's some work to do before it makes business sense to the workplace. That's just my view.
It's something that we can discuss more, I believe, because I am pro creating a business case for OSH, even as we are now. But yes, I think that, Mr. Bere, these are the questions that I think are the hard ones now. Along the way as we move, we should be able to demystify so that we all appreciate why we should, which role we have in maintaining safe work, safe and healthy working environment. Yes.
And then, your parting shots as we close?
Well, the truth is that for anybody that wants to have an effective management system in any workplace, I am a fan of ISO. Ensure you plan. You have systems in place to plan for safety. Don't be ad hoc, cannot be an effective way of managing health and safety affairs. Have systems to implement, be ready to invest. And not everything is about money. Some investments are about time, some investments are about strategic thinking, allocating responsibilities on a certain person without necessarily introducing new people. So put systems in to implement and then monitor. Even at government level, enterprise level, is very important so that you can track progress and then ensure that when you find those gaps, you act on them. I find that ideology of management system perfect for any enterprise. Yes.
All right. Thank you for watching this show. If you watched this part, means you're really interested in this topic.
Yes.
I ask you to subscribe to this channel so that you can always access this content whenever it's available. My message to the industry and professionals: get behind the Department of OSH and the law as it is, and contribute to it positively, implement what is possible. If you're out there and as an organization and not sure what you need to do, contact the Department of OSH. We'll be able to explain to you how you can get compliant. Don't wait for them to visit you. You can actually invite them to come and see what you're doing, how you're doing it, and ask for their advice on how you can do it better. And they will be able to support you one way or another for God and my country, as we say. Thank you so much. Until we meet again in the next podcast session.